Hello and welcome to this afternoon's webinar, The Classical and Christian Origins of American Politics. My name is Garrett Snedeker, and I'm the Deputy Director of the James Wilson Institute. The mission of the James Wilson Institute is to restore for a new generation of lawyers, judges, and citizens the understanding of the American founders on the first principles of our law and the moral ground of their rights. To this end, we've designed programs to cultivate an appreciation for an approach to the law that unfortunately is not taught widely in the academy, a serious study of the moral ground of the law and the logic of natural rights. And today's webinar is one of those programs. We're pleased to be sponsoring this webinar with our friends at First Liberty Institute's Center for Religion, Culture, and Democracy, CRCD, as well as the Civitas Institute at UT Austin. The CRCD envisions democratic societies which affirm the essential role of religious convictions, peoples, and institutions in cultivating free and flourishing communities. To achieve its vision, the CRCD supports the creation and promotion of high-quality scholarship at the intersection of religion, culture, and democracy. The Civitas Institute is a new project at UT Austin for the study of the foundations of free society. You may visit civitas.utexas.edu to learn more. Now it's my pleasure to introduce you briefly to our two lead panelists and then our main respondent. Our two lead panelists are the authors of The Classical and Christian Origins of American Politics. First, Justin Dyer is director of the Civitas Institute, professor of government, and Jack G. Taylor Regents Professor at the University of Texas at Austin. He is a James Wilson Institute affiliated scholar and a member of the James Wilson Institute Fellowship faculty. Cody W. Cooper is UC Foundation Assistant Professor of Political Science at the University of Tennessee at Chattanooga. He is the author of Thomas Hobbes and the Natural Law. Following Professors Dyer and Cooper will be a response from Dr. Jordan Ballor, Director of Research at the CRCD. In addition, he is Associate Director of the Unius Institute for Digital Reformation and Research at the Calvin Theological Seminary and the Henry Institute for the Study of Christianity and Politics at Calvin University, with interests including Reformation studies, church-state relations, theological anthropology, social ethics, theology, economics, and research methodology. And so before we get started, just a few brief notes on our webinar today. As you can see on the screen before you, our webinar is being recorded, and you'll have a chance during the conclusion of our panelists' remarks to participate in Q&A, and you're encouraged to submit questions in advance for Q&A, just so we'll have an idea of how the queue is moving. But you will be able to ask your questions using your laptops or devices audio feature. However, if you'd prefer us to ask your question or you'd prefer your question to be anonymous, just let us know and we'll gladly read it. Just please use the Q&A function on Zoom towards the bottom of the Zoom app. If you need to communicate with the staff for any technical issues, or if you have a more general question, please use the chat feature on Zoom. Our intern, Jacob Shields, is monitoring the chat feature and the Q&A function closely, and you have our contact information as well if you have any questions in particular that you want to reach out to us for. So with that, it's now my pleasure to turn the webinar over to Justin Dyer to get us started. Justin.
Thank you, Garrett. Thanks, everybody, for joining us today. I appreciate the James Wilson Institute for organizing the panel. Thanks to the First Liberty Institute. And thank you for the plug for our new project at the University of Texas. I've anglicized the Latin and have been saying civitas. And then the church Latin folks say civitas, and the classical Latin folks say civitas. But it's civitas.utexas.edu if you'd like to take a look at what we're up to here. I left the University of Texas for a number of years and just recently returned, but had done graduate school there. And when I was in graduate school, I wrote a dissertation on natural law and the anti-slavery constitutional tradition. That turned into a book, and one of my dissertation committee members, when the book came out, wrote me a note, and it said, "Great job, congratulations, really enjoyed it. But here's my longstanding criticism of what you're doing." And he said something like this. He said, "Nature's God is not the God of Abraham. Natural law is not an adjunct of, but a rival to the divine law. And if you can show otherwise, there's an article or a book waiting to be written." And so I've been thinking about that for years. And this project grows out of that challenge, this question of the character of the American founding and the character of those self-evident truths that we find in the Declaration of Independence, and the place or role of natural theology as you find it in the Declaration, and this emphasis on the laws of nature and of nature's God. And this question launched me into this research project, and Cody Cooper joined the research project. He's a fellow University of Texas PhD graduate, now at the University of Tennessee, and we've worked on this now for a number of years, thinking through this question. And it brings us into an interpretive study of the American founding. And I think right now, at this moment, it really is an important question for us to revisit. It involves this ongoing scholarly debate about the founding, about its character, about its liabilities. And our argument here and our contribution, what we're trying to demonstrate, is that the natural law tradition that's publicly invoked in the founding era owed more to classical and Christian sources than to their modern and secular alternatives. And we developed that argument through close readings of the pamphlet debates, the 1760s and 1770s. We have an analysis of just war theory and the War of Independence. We look at founding era invocations of providence and providentialism, debates about sovereignty under the US Constitution. And we have separate chapters on the political thought of Thomas Jefferson and James Wilson, respectively, and they each present their own challenge from different angles to our thesis that we try to address. And what we find and what we argue is that the natural law tradition in the late 18th century United States was predominantly classical and Christian. And by that, we mean a conception of natural law that affirms distinct things. And so I want to go through this list with you, and you'll have to stay with me because it has very specific ideas that we're looking for, analytically looking for in these founding era sources. The first is that natural law has a lawgiver, and that lawgiver is understood as a creator who is separate and distinct from creation. And we understand this conception as classical and Christian when we compare it to what it is not, some idea of a kind of pantheistic God that unites nature and God together, that nature's God would just be tantamount to nature. And we think that's not actually what we're finding in these sources. The second thing is that human reason, our ability to reason, allows us to grasp basic human goods that are real and not nominal. They're not good in name only, but they're really good, that there are real human goods that reason can grasp. The third thing is that natural law is prescriptive, that it imposes obligations that we know by reason, and it's not merely descriptive, offering hypothetical imperatives. In other words, what we can reason about is not simply an observation of how the world works and a hypothetical imperative. If we want X, then we can do Y to get it, but it's an actual obligation imposed on us that we know by reason. The fourth thing, that natural law emanates from the nature of God, and in the nature of God, there's a unity of power and goodness. And that sounds like an obscure theological debate, that in some ways it is, but it's one that the founders were well aware of, that they addressed, and that they decisively came down on one side of that question. God's sovereign authority, then, in this view, is the thing that grounds moral obligation. And that moral obligation and God's sovereign authority to impose moral obligation is not the result of superior physical strength alone. It's not simply power, but it's united with goodness. It's power and goodness together, which gives that authority. By analogy, then, sovereignty in a rightly ordered political community is modeled after this pattern of divine sovereignty, where unity, there is a unity of power and goodness. Power alone does not confer sovereign authority, both in theology and in politics. And so what that takes us to as the sixth thing is that the rule of law means that the sovereign is subject to and bound by a higher moral law. Might does not make right. And absolute sovereignty, understood as the imposition of the sovereign's will, is analytically indistinguishable from tyranny. And so then the seventh thing, in the social contract, and in social contract theory, as the Americans are Deploying it, sovereignty is derived from the consent of the governed, but sovereignty remains subject to a higher law. The people who are sovereign can't exercise, or at least do not exercise, an absolute sovereignty based on will alone. And so as a result, consent is a necessary but not a sufficient condition for the rightful exercise of government power. The people, as the sovereign, are still bound by this higher moral law. And then finally, the eighth thing, natural law is known by reason independent of revelation, but they're not mutually exclusive or contradictory concepts. And each one of these things collectively make up what we call the classical and Christian natural law tradition. And what we consider to be distinctly modern and secular conceptions of natural law are understood in contrast to these elements. By contrast, the modern and secular conception of natural law holds to a pantheistic conception of God, in which God and nature are one. God is not a creator, independent and distinct from creation. These conceptions treat the good as nominal, in name only. They treat natural law as hypothetical, sovereignty as unlimited, the rule of law as indistinguishable from the rule of will, consent-based social contract theories as conferring sovereign authority that is unlimited by a higher law, and reason as standing in opposition to revelation. And in the book, we simply use the term for this modern natural law vision, or this vision of modern natural law, we use the term Hobbism, relating to Thomas Hobbes. And we're following here a term that was used in the 17th and 18th centuries to broadly summarize this constellation of ideas. And again, this is exactly what you find in founding era sources. They are aware of these debates. They derisively associate these ideas with Thomas Hobbes, and they dismiss them. And so each one of these things that we're looking for analytically in the founding, we find in the various debates that are influential, both in the founding era, in independence, and in constitution making. And so this is the methodology of the book, is identifying what we mean by classical and Christian, and then looking at these various episodes in the founding era and asking whether the ideas that are being invoked and being communicated fall on the classical and Christian side, or whether they fall on the modern and secular side. And the argument we have is that the dominant tradition, the dominant strand, it's not simply that there's a multiple traditions approach in which all of them are equally constitutive of the American regime. It's that the dominant strand really is compatible with and developing out of this classical and Christian tradition. And so I'll turn it over to Cody now to give some examples of how we actually develop that argument in some of these chapters.
Thank you, Justin, and thanks to James Wilson Institute and our fellow panelists. Looking forward to talking with you all, and Justin just ended there talking about Hobbes, and I just reflected in recent days, maybe for the first time in American history, in Arizona now, we have a Hobbesian state.
Right.
I can't tell if that joke's landing out there. I can't see all of you, but I can't resist. Hobbes scholar here. So let me zoom in on a couple of the chapters that we, where we give evidence for, to try to illustrate these principles Justin was just talking about. So one of the things we get into is the pamphlet debates, the sort of transatlantic contest by word and mouth that took place roughly between the early 1760s and up to 1776. One thinker we zoom in on is James Otis, and people like John Adams talk about how foundational, how important Otis's work was for the whole patriotic argument through the pamphlet debates. And indeed, Otis, his work on the writs of assistance cases was one of the sparks that led to the whole revolutionary movement, according to Adams. And his pamphlet, one of the most widely read and influential, the Rights of the British Colonies Asserted and Proved, is one place you can go to see where some of these principles shine through. And he was arguing against the Stamp Act. And one of the questions he asked is, what is the foundation of government? And he says, well, it could be force, it could be grace, it could be property, It could be the social compact. He says, no, the very first principle is and I'm quoting now, the everlasting foundation, the unchangeable will of God, the author of nature, whose laws never vary. That same omniscient, omnipotent, infinitely good and gracious creator of the universe, who has been pleased to make it necessary that what we call matter should gravitate for the celestial bodies to roll round their axes, dance their orbits, and perform their various revolutions in that beautiful order and concert, which we all admire, has made it equally necessary that from Adam and Eve to these degenerate days, the different sexes should sweetly attract each other, form societies of single families, of which larger bodies and communities are as naturally, mechanically, and necessarily combined as the dew of heaven and the soft distilling rain is collected by all the enlivening heat of the sun. Okay, that's one of those great, like, Hookerian, like, multiple page long sentences. But so there's a lot there, and I think that a lot of these principles we're talking about classical teleology and Christian theology shines through. One of the great political theorists of the 20th century, Ellis Sandoz, suggested that Otis, that his theistic natural law theory was actually essentially Thomistic, which is to say, in the spirit of Thomas Aquinas. And I think there's something to that. And Otis's theory, I think, illustrates a lot of what we're talking about this broad classical law, natural law tradition in its axiology, that is to say, its account of the human good. There's a classical anthropology of human beings here as naturally social and political animals. And that nature is itself divinely pedigreed. It's existentially dependent upon God's creative act. Some recent work and work that has a lot of good that I appreciate it, but some that I disagree with, such as political scientist C. Bradley Thompson, argues that the founders discarded natural teleology, that they affirmed the Enlightenment sort of mechanistic science of Copernicus, Brahe, Galileo, Newton, and affirmed the epistemology and metaphysics of Locke in the essay on human understanding. So we argue against that in this book, and it is true that Americans like Adams, Jefferson, Wilson praised people like Bacon, Newton, and Locke, but they were selective in their praise, and they filtered aspects of these thinkers through their Christian natural law sort of view. So they didn't reject teleology in our view. So someone like John Adams spoke, for example, of, quote, how every animal that we see in this prospect, men and beasts, are endued with the most curiously organized bodies. They consist of bones and blood and muscles and nerves and ligaments and tendons, a million other things, all exactly fitted for the purposes of life and motion and action. That's just one example. We talk about in some of the chapters about Thomas Jefferson, James Wilson, and the evidence in their writings for affirming teleology. Indeed, Jefferson deployed a teleological argument for God's existence, inferring from the order and harmony of the universe that there must be a creative architect. In the letter he discussed this. He explicitly rejects Spinoza and other French philosophers like D'Holbach. And many Americans argued that God's existence could be proven by unaided reason, even if it was also held by Christian faith. They saw reason and faith as working in tandem. Someone like John Witherspoon said, quote, from reason, contemplation, sentiment, and tradition, the being and infinite perfection and excellence of God may be deduced, and therefore what he is and commands is virtue and duty, end quote. But going back to James Otis for a second, he said, look, what was the answer to the question of the foundation of government? It's immediately on the necessities of human nature and ultimately on the will of God, the author of nature. So, right, why would this matter for the imperial dispute? He deploys it to reject voluntaristic and positivistic accounts of morality and law, right? Just because Parliament commanded it did not ipso facto make it to bind. should an act of parliament be against any of his natural laws, which are immutably true, their declaration would be contrary to eternal truth, equity, and justice, and consequently void. So one of the great axioms of the classical natural law tradition: an unjust law is no law at all. And what is meant by that is that it in as much as it fails to meet certain moral criteria, it fails to bind in conscience as law. We talk about some of the other influential pamphleteers in the pamphlet debates. John Dickinson, who is also a Christian theistic natural lawyer. Alexander Hamilton, who we talk about in some detail. You may recall that in Hamilton's pamphlet leading up on the eve of the Revolution, he argued against Royalist Episcopalian Bishop Samuel Seabury, and he said, right, good and wise men in all ages have supposed the deity, from the relations we stand in to himself and to each other, has constituted an eternal and immutable law, which is indispensably obligatory upon all mankind prior to any human institution whatever. End quote. Let me go into more detail into the pamphlet debates and give numerous other examples. But another chapter I'll mention. I did talk about Jefferson a little bit already. To say a little bit more about that, Jefferson is a challenge to our thesis because I think it's pretty broadly acknowledged in the scholarship that he is more theologically heterodox and philosophically skeptical at the very least. And yet we argue that he did affirm a creational metaphysic and a natural law theory of morality. He was proximately influenced by some of the Scottish common sense moralists, which we argue was sort of mediated a lot of the classical natural law principles that he affirmed. Talk about his view of conscience. And he also strikingly at one point in his letters, this isn't your high school Thomas Jefferson, quotes Thomas Aquinas and his explanation of the existence of the universe relationship to God. I think is pretty striking and amazing, and shows how he affirmed an idea of existential dependence, and that would matter for a natural law theory if you think that moral norms need to have some divine pedigree for them to be binding as law. And the founders seem to have thought that. Another chapter gets into some of the debate over the normative justifiability of the revolution. And so we apply the Christian principles of just war and just law broadly within the framework put forward by Thomas Aquinas, and give an analytic argument the revolution was in principle justifiable from the perspective of classical Christian natural law theory. And we focus on the jus ad bellum there. Now, we don't really have the space to go into jus in bello. And there's things to be said negatively on both sides of the war in that respect. But we do look at the question of whether or not the principal actors in the revolution believed in providence, which is, but more specifically, particular providence, that God governs the affairs of men, as Franklin put it in the Constitutional Convention. You could look at that and say, oh, that's kind of, that's kind of post hoc rationalization, and maybe it's just Franklin throwing out something, as mere rhetoric to as a tub to the whale, or something like this. And so, right, but what if you go back and look at the actual actors in the moment, and we do this through case studies of counterintelligence and diplomacy and the Southern Theater during the war, which are the three areas that the Continental Congress sets forth as evidence of divine favor. And right, looking at John Jay, the Franco-American diplomacy, Silas Deane, Franklin, Pierre Beaumarchais, the Culper Spy Ring, it's pretty incredible. You find that these actors take them, whether it's true or not, set aside, they take themselves to be over and over acting within a cosmic drama of which they are players, and it's governed by a superintending intelligence. And we also go into sovereignty and how the founders understood the idea of popular sovereignty, and particularly in the constitutional debates, the Constitutional Convention, and subsequently. And there's a lot of scholars out there who claim that it's sort of a positivistic, voluntaristic, nominalistic notion of sovereignty, with no vertical limits. And we argue that's incorrect, as if in light of the rest of the book, that's what you would expect. And we sort of go into Orestes Brownson a bit, and he has a really interesting account of sovereignty within the scheme of providence, that I think is enlightening, in that we make the case that it is. And then finally, we have a case study of maybe not surprisingly, James Wilson, whose lectures on law were deeply informed by classical natural law principles. So anyway, that's a very short outline with zooming in on some detail. I'll just pause there and turn it over to, I think Jordan has some comments and questions for us.
But before we get to Jordan, just a very brief introduction. An unexpected surprise: our founder and director of the James Wilson Institute, Hadley Yarkis, is with us. I'm sure he'll have a bit to say after Jordan, before we get started in the Q&A. But just wanted all of our attendees to know just why there was a fifth screen to appear before them. Oh, Hadley, you're muted. It's
Garrett is getting me in here because I couldn't break in. So breaking in, I asked to say a few words. It's like I used to say, I just came in to read the meter, and people ask me to say, but I do want to break in because I think this is a magnificent book. And on that, I'll have more to say when we have the discussion. Thanks for inviting me in.
Mhm.
Sure. Well, as a prelude to my brief comments, let me just second Hadley's endorsement for the book. It is excellent. I learned a lot reading it. My background is not in political theory or in early American history. It's in historical theology and intellectual history, focusing on the Reformation and post-Reformation periods, although I've been getting into, later into the 18th century more and more lately. Let me just open with a quote from the 19th century, since we're speaking historically, from Pope Leo XIII. In his encyclical Rerum Novarum, he says, when a society is perishing, the wholesome advice to give to those who would restore it is to call it to the principles from which it sprang. And that's in some real sense the what I take to be the mission or the hope of this volume from Justin and Cody. It's to call political theorists, political scientists, historians, anyone who will read the book back to the principles from which America sprang. And it's a clarification of what those principles actually are, because of course there are many debates about the nature of those principles, what they entail and what they are in substance. A few points I want to raise, because I could spend the whole 10 minutes basically praising aspects of the book, but a few points I want to raise that I thought, as I took notes, were the sort of the most interesting, at least to me, both in terms of the substance and perhaps the implications of the book. I've got a few points here that I'll bring up. The first is whether we can speak sensibly about something that we might characterize as an American Enlightenment. It's pretty typical in at least the older scholarship to juxtapose the Enlightenment against classical and Christian theology, and the Enlightenment is a reaction against those things. To some extent, that's true, depending on the individual thinker that you're looking at, and to some extent, it may be more or less true depending on the nature of the Enlightenment that you're examining. We could talk about multiple Enlightenments, and in fact, the scholarship has begun to do that, distinguish between the German and the French, and the Scottish and the English Enlightenment. If that's a legitimate kind of framing, it could be that this book helps us to understand the founding era as a kind of an era that's characterized by something like an American Enlightenment movement. which is, to use the words of Robert Cranach, which are quoted in the book, a kind of blended Scotch, which I think is a wonderful image to think about this synthesis that's going on here that we find explicated in the volume between the classical and Christian traditions. And it's Scotch in a deeper sense too, because of the relationship between many of the founders and these founding principles and ideas and the Scottish Enlightenment, which among the Enlightenments is perhaps the most friendly to traditional religious belief, Orthodox Christianity in many cases. Figures like Witherspoon and Wilson are important here and receive good treatment in this volume. The American and the French, revolutions share many similarities and affinities, but of course they are distinct in many ways too. And so perhaps analogous to that, there are also two Enlightenments. And we might say that the Enlightenment in its American and even Anglo-American and Scottish formulations were not so hostile to Christianity as much of the older scholarship might have us believe. And again, the older scholarship surrounding James Wilson that's engaged critically in this book, I think is paradigmatic of this kind of approach. The second point I want to raise has to do with Thomas Jefferson and the excellent treatment of his metaphysical beliefs, his beliefs with respect to transcendent reality and so on that the book gives. There's a letter that Cody's already referred to that's quoted here in the book in which Jefferson explores arguments from design or teleology in the natural order. What was interesting to me as a Reformed theologian and Reformed historical theologian is at the beginning of this letter, it's from Jefferson to Adams in 1823. It opens this way with engaging explicitly the theology of John Calvin. Jefferson says, "I can never join Calvin in addressing his God. He was indeed an atheist," that is, he's speaking of Calvin, "which I can never be. Or rather, his religion was demonism. If ever man worship a false god, he," that is Calvin, did. "The being described in his 5 points is not the God whom you or I acknowledge and adore, the creator and benevolent governor of the world, but a demon of malignant spirit." So there's a lot going on there, obviously, in Jefferson's characterization of Calvin. But one of the interesting things is in later lines, one of the things that he seems to be criticizing Calvinism for, at least in terms of the substance, is this idea, and this is to quote Jefferson, that, quote, "without a revelation, there would not be sufficient proof of the being of a God." That's the proposition that he is saying is represented not just by Calvinism, but by every Christian sect. And so that's one of the points of disagreement that Jefferson has with his conception of Orthodox Christianity. Well, this volume does a wonderful job, I think, putting the lie to that kind of perception or characterization of the classical Christian tradition, especially with respect to natural law. It does a great job unpacking the relationship between natural revelation, natural theology, and the implications for civil order, both in theory as well as in practice in the era of the American founding. We might say in a kind of synthetic sense that the same knowledge of God that for Orthodox Christianity and certainly in its Calvinistic expressions leaves sinners without excuse, the same knowledge that leaves them without excuse before God, also makes possible human government, because it communicates this relationship, this necessary relationship between creator and creature, and absolute sovereignty on the one hand, and the relativization of sovereignty and law and justice on the other. So we get this sense, a consensus, we could say, that the higher law appeals in the founding era require a higher lawgiver, and the characteristics of this higher lawgiver may not always be agreed upon in all the details. That's why we have Christian sects, and you have theists who are not orthodox in terms of their religious beliefs, so they disagree in some of the details, but there is, I think, and this book shows that there's a consensus about some of the key figures of this lawgiver and the nature of the higher law or the natural law in the founding era. The last point I want to make, and I think this helps underscore the case that Cody and Justin make quite well in the book, is the connection here between classical, what they define as classical, and Christianity. They define Christianity really well in the book and say they're talking essentially about creedal Christianity, and then they clarify when figures like Franklin or Jefferson or Paine, whoever, seems to depart from something like creedal Christianity. one text that comes up over and over a number of times in the volume from the primary sources is Acts 17:28, and the line, "In him we live, move, and have our being." This is a quote, obviously, from Paul's speech, but Paul here is also quoting classical ancient authors. There's a debate whether it's Epimenides of Crete or Euripides, but this example of Paul's speech in Acts 17 is, I think, another important bit of evidence that there is not necessarily an antagonism between the classical and the Christian views, and that the Enlightenment in embodying, classical, a rebirth of classical knowledge, therefore necessarily opposes Orthodox Christianity. There are certainly versions of Enlightenment thinkers who do that, but there are many, and many of which are explored in this book, who do not. So take up and read. I know the book will be out soon, and hopefully many of you have pre-ordered, but I highly recommend it.
Thank you, Jordan. Hadley, I'd like to invite you to offer some thoughts of your own. If not, I'm happy to kick off the Q&A, though. Oh, just remember to unmute.
No, I'll take a review, but I thought it was such a splendid commentary from Jordan. It was a pleasure to listen to that too. Like I said, this was a magnificent book. I remember years ago, Dan Robinson had this remarkable book with a couple of chapters where I said, if the elves could come in the middle of the night and deliver them to my resume, I wouldn't. I'd steal this whole book. It's a magnificent book. It's not merely a book for the best book of the year. It's a book for a generation. It will be counted as one of the very best books on the American founding. And it's beautifully written. But where to cut into this, I was very taken with that critical point that we're dealing with a law that God himself would respect. So you think of Abraham negotiating with God over Sodom and Gomorrah. Shall the God of the universe not himself be just? And some people say, well, he's not arguing with God as to whether God understands his own revelation. He must be appealing some principles that he expect God himself to respect. You think of Fletcher versus Peck on the old case of violating a contract, and Justice Johnson said, in a concurring opinion, he's invoking the principle on ex post facto laws, and he says, yes, I'm striking this down, not on the basis of anything in the text of the Constitution, but on the basis of a principle that would give the law even to the deity, right? And you made me think of Wilson relying on Burlamaqui, picking up that critical point that that Justin and Cody have made, that the natural cannot depend simply on the fact that it emanates from a lawgiver. It makes power the test of the argument. And Wilson referred to Burlamaqui, saying, well, there are two sources. One, the law's law because it emanates from a lawgiver, or because we think it's in accord with reason. And Burlamaqui says, yes, but when it is in accord with reason, it confirms our sense that it must proceed from the lawgiver. And of course, I assume that seemed to be that Justin and Cody were encompassing the possibility that these people would be disagreeing. We'd have serious disagreements among the founding generation and others, but the disagreement would not indicate the absence of truth. You know, as Justin points out, citing C.S. Lewis, that any conversation presupposes that there must be standards of judgment in arriving at right or wrong answers. Otherwise, the conversation makes no sense. So we have people like our friend Justice Scalia says, the natural law can't guide us because there are too many disagreements about it. No, that doesn't count to disqualify the natural law. But there are a couple of questions that sprung up when either you say, well, okay, bring that to the, you were rightly use the youth pro. Is it good because God directs it, or we assume it comes from God when we understand that there's something enduringly good and rightful about it? And so when you say, well, They're the natural laws, but now we're in the domain of freedom, of course. When we're casting judgments on people, we're in the domain of freedom. This is one place where I think, forgive me, that Kant would have helped. The laws of freedom. You say, why are we obliged to respect these laws? We could fall into contradictions without collapsing. The answer was, well, if it's a law of reason, like the law of contradiction, it commands your obligation as a law of reason, that you fall into gibberish if you tried somehow to evade it. But there are a couple questions spring up, and I want to get your thoughts on it. We've been confronting always the question of, well, all right, but when should judges invoke the natural law? Somebody say, well, the time you're asking that, you're asking the wrong question. So when somebody comes to you, what's your take on this? We have some of us say, well, look, it's been with us all the time to ask whether I can get through the day without using the natural laws, like asking, can I order the coffee without using syntax? So, well, I'm sorry, what's your take on? And also another question about how the families, with this perspective, would understand religious freedom. Remember, Washington, in the letter to the congregation in Newport, it says, we're long past that period of tolerance. We understand there is a natural right to the religious freedom. Well, natural right means accessible to our reason, is an understanding of why these people ought to be respected, even though you don't credit for a moment the truth of their theology. So I'm wondering what's your take on either one of those problems? What would they say about, we have Satanism as a religion. Some of us think there's no way that the God of the Declaration of Independence would be relativistic on the question of whether the affirmation of radical evil would count as a legitimate religion in this country. But just what's your take on those kinds of things?
Well, thanks, Hadley and Jordan, for those comments. I'll jump in and offer one answer, and then Cody, you might take the religious liberty question, which comes up in our conclusion. I was thinking, Jordan, as you were talking about the multiple traditions or the blended scotch of the American founding, and often how this comes out in debates is that you can identify certain strands of thought. And so people will point to the liberal tradition or point to a Republican tradition, and then they point to Christianity as though it's a distinct tradition, and then the Scottish Enlightenment as a tradition. And that way of framing things assumes that Christianity and what we're calling the classical Christian natural law tradition was not itself part of each one of those traditions, shaping it in how it comes forward and how it plays out in the founding. And we see this as something that is pervasive in the education of the founders. There's a wonderful book by a man named Walsh, who published a book in the 1930s on the education of the founding fathers of the Republic. Mm-hmm. And it lays out the curriculum that they had at the colonial colleges, and the classical natural law tradition was central to the types of questions that they took up. And so we see this going throughout. And Hadley, your question is about judges. What's the difference? What difference does it make for judging? Is there a way in which you can reject the natural law? And my answer to that is that you can reason well or you can reason poorly. And so you can have better or worse examples of natural law jurisprudence, but there really is no escaping it. There's the metaphor of singing, I'm not singing, but you're still singing. And there's a way in which a judge can say that he's not doing natural law. And Justice Scalia, I think, fell into this many times. And he, despite his protests to the contrary, he just was doing natural law often, because there are points and turns in the argument in which you have to make a judgment. And if the task of a judge is to make a judgment, and the judgment has a relationship to reason, if it's not going to be arbitrary, and arbitrary is literally lacking a reason, you're going to make a judgment and you're going to reason. And even the arguments for judicial restraint hinge on a conception of the proper authority of a judge, of the moral underpinnings of the regime, of what the task of judging entails, of what the proper role is in that case and for these parties. And so even in giving an account of the restraint of a judge, you're going to be put back on some moral conception. And so I think it's always with us. We can do it well or we can do it poorly, but we ought to understand these things as best we can. And in our project, we're trying to lay out the background architecture, the intellectual architecture of the American founding. How are they thinking about these questions? And those background principles just are going to inform how we understand our institutions, how they operate, how they're designed. That involves understanding the Constitution and, of course, understanding the judiciary. And so from the internal perspective of a judge, there is no escaping these kinds of questions. And so we have to engage them. And one last point, and then I'll let Cody talk a bit about religious liberty. The project itself, we started years ago, and so we didn't quite anticipate the particular moment that we would be in, but it's a moment in which you have significant criticisms of the American founding from both the left and the right, or right might not be the right word, but what goes under the banner of post-liberalism. And so you have progressive critiques, but you have post-liberal critiques of the founding. And just a word about that before turning it to Cody, there's a way in which, of course, we would agree with the critique if we thought the account of the founding were correct. And so what we end up calling Hobbism, and what we think the founders identified and decisively rejected at each point as they considered the alternative, if that were in fact the true character of the American regime and the true character of the American founding, then I think we would be all on board with trying to do something different. But as it is, I think a careful analysis of what's going on here, there are principles that put themselves forward as not just historically interesting, but as true. And we can consider the truth of those claims and consider the choices that they're making and consider the way in which those principles can still guide us today. And so this is an important moment, I think, for this debate. It's one that we're having with a lot of our friends, and we hope we make some contribution to that. Cody, do you want to talk a bit about
May I just break in quickly to say, and I'm glad we had a recording of that. That's about one of the best one could be given. You know, I used to say to Scalia, for somebody who, you often give us a fine, for somebody who denies the natural law, you often give us a handsome expression of it, at the same time consisting up and down that it can't be done. But so your answer though, our judges come to us and say, when is it legitimate for judges to invoke the natural law? And I gather your answer come along is that, from what you just said as well, if you're not in the domain of arbitrariness, if you feel obliged to give reasons, guess what? You're in the world of natural law right now. Is that fair to say?
I think that's fair to say. And the question, when is it legitimate to invoke the natural law, is a different kind of question in some ways, is when is it legitimate to reason according to the natural law? And this reminds me, Dick Helmholtz has this book on natural law in court, and his methodology, which is interesting, and he makes a good point in the book, but his methodology is to comb through all of the cases that we find in the common law and in early American jurisprudence and ask, when did the judge invoke the natural law? And so you can do a kind of word search and you can find all of these various permutations of natural law or law of nature. But the real question is not when do they invoke it? When do they explicitly say, I thus invoke the natural law? And when are they just doing that in their arguments? And this is the point, Hadley, that you make so often, but that we can find in Justice Scalia's jurisprudence and others when they are adamantly denying the possibility of natural law jurisprudence and just doing it. And so having that kind of analysis, and that's partly what we're doing in the book, is we're asking about the founding, not just when do they explicitly say X, Y, or Z, but if we look at the structure of the argument that's being put forward in the pamphlet debates or somewhere else, what is it that they're actually arguing? And for a generation of scholars, I think what they were looking for was something like, well, when did they cite the book of Deuteronomy? Or, when do you have an explicit invocation of some Christian idea or some classical idea? And what we're saying is that you can, with this analytic framework, you can demonstrate that this just is what they're doing so often.
Of course.
So just a brief comment on the two images that came up during Justin's answers there. I'll start with the second one first, because I think it'll feed right into Cody's comments about religious liberty. But you can sing without saying I'm singing too, right? And that's a really important point. I think so many contemporary defenders of the natural law think I have to be explicitly invoking the natural law all the time as some kind of, I have to call it that or something like that. and perhaps to extend the analogy too far and out of an ignorance of actually how Scotch is made, is it more like the water, this Christian and classical tradition, than reducible to any one of the single ingredients, something like that? Anyway, I'll leave it there.
Okay.
Okay. So to the question about religion and how to define religion, it's a great question, and one we do get into a bit in the conclusion of the book. Because within classical natural law, religion is a good, and it is as accessible by unaided reason, known that something is owed to a creator, to a single God. And whether you're in the Stoic tradition, or you want to trace it up to the Scholastic, or the sort of whether in sort of medieval Scholastic or the Protestant Scholastics, there's this idea that religion, you can know that something is owed to God, and that involves some kind of sacrifice, and moral duties have a relationship to this being. And so when you read Jefferson in the Memorial Remonstrance, he says, religion, or the duty that we owe to our creator in the manner of discharging it. That's a theistic definition of religion. And it's the foundation of religious freedom is the fact that you have this duty transcends as prior to the political community. It's so important that coming under the coercion of the political community is bad. But it's grounded in a prior duty. It's not a Hobbist state of nature where you have a right to all things, and then you kind of pull duty out of that hat, out of the state of nature hat somehow. No, the obligations, the duties, in virtue of the various goods which participate in the divine uncreated good, and which are the perfections of, or the objects of striving of human nature. Among those is the relationship with the creator. And so this definition of religion, I think, is presupposed, and it is coupled closely with morality. So, when George Washington gives his farewell address, which he expected would be read and meditated upon throughout the life of the Republic, he very quickly and highlights the indispensable pillars of human happiness: religion and morality. And so I think that the idea that a religion would be theistic, it'd be monotheistic, and also be moralistic, in the sense of a set of moral principles would be part of that. And so a claimant to be a religion that flouted the existence of God, or flouted morality, would look like, at best, a peripheral case of religion, I think, to the founders, and probably just not a claimant to it. Now, that doesn't mean that, if the church of this flying spaghetti monster is worshiping down the street, that we can bust down their door and arrest them just for that. No, there's freedom of speech, there's freedom of assembly, et cetera, et cetera, et cetera. That association that would protect such gatherings, but to make a claim upon, as a matter of constitutional jurisprudence, in the name of the founding political philosophy of religion, I think there are some necessary conditions to it, and that is controversial to claim that, because we are much more pluralistic religiously today than we were at the founding. And so, yeah, there's a bullet one has to buy. And I'm just speaking in my own capacity here. I don't know if Justin would agree with this, but in terms of that question of how one goes about contemporary religious freedom disputes, one has to buy. If one has a definition of religion as just the highest good of my life, well, then anything counts as religion, right? As ultimate concern, as Paul Tillich would say. Well, now there's nothing distinguished from religion in just any worldview. So we have to have some definition. And if we're interested in what the founders had to say about this, that's one possibility.
Well, this is great. I think it sets the table nicely. We have a few questions already in the queue. I'll start with a question from our friend Dave Collins. He asks, at the risk of pulling you outside the scope of your work, This is to Justin and Cody. Do you have any views about how the 19th century framers of the 14th Amendment differed from the 18th century founders in their understanding of natural law and its role in constraining their lawmaking?
Good question. Yeah. I don't.
That's a great question, and
Yeah.
I don't know. I'd really have to think about that. I wouldn't be able to go through one by one each of the framers of the 14th Amendment and give an account of how they understood natural law. And so that certainly is above my pay grade. But thinking about the consistency, as I see, the consistency between the principles of the 14th Amendment and the principles that animate the American founding. Now, you do, of course, have a change to American federalism. You have a constitutional change. And there's an analytic question that people like to debate about whether or not this constitutes a development of those founding principles or whether or not it is a new course. Are we doing something constitutionally revolutionary by amending the Constitution in that way? That was the early debate on the Supreme Court in cases like the Slaughterhouse cases, as the judges are anticipating and asking just how revolutionary this change was. But my own take on it, and this is from reading the debates in the 39th Congress over how to amend the Constitution and what the point of the 14th Amendment is, that the people on the floor who are arguing for this are arguing that this is a growth and a development from these original founding principles. And so I see the principles animating the 14th Amendment about equal protection, about citizenship, birth citizenship, in the background, of course, the background context of the rejection of those things in the Dred Scott decision, that what the 14th Amendment is doing is making good on the promise of the founding. And so I see those things as deeply consistent.
Well, one possibility, of course, is that you recognize that these were the Congresses that were coming down heavily against polygamy,
hmm
right?
The
Now,
twin relics of barbarism.
during the Arcs of Barbara, slavery and polygamy, and so you could say, well, polygamy was in the Bible, which means that no, they were taking more the natural law, natural law, the reasoning of natural law, undergirding their religion, their understanding of what religion would encompass.
Mhm.
I would just also throw out there to the questioner that a book that will be worth checking out is a recent book by Stuart Banner. Is I think UCLA law professor. It's called The Decline of Natural Law. But his historical account of thinking about natural law in the 19th century is really good, and it's one of the best I think accounts, and specifically in courts and how lawyers and judges use natural law rhetoric. And I think that he shows that there was a fairly consistent tradition about fundamental assumptions about natural law and its role and legal argument, but also its content up through the end of the 19th century. Now, he also doesn't cover over, I think, legitimate points to be made about debates over women's rights and property rights, and there are debates but the debates take place within a shared moral framework, though. So anyway, that's one book to maybe look at for more insight to that.
I'll add that Randy Barnett and one of our James Wilson Fellows, Evan Bernick, also authored a book that came out last year, The Original Meaning of the 14th Amendment, in which they largely come to the conclusion that the drafters of the 14th Amendment were trying to channel common law through a much more positivistic lens, at least if you are to look at the project of what they were attempting to enact. It probably would not be leaning as strongly on the ability of other actors in the constitutional scheme to be able to tap into moral principles. Now, that isn't without other scholars disagreeing with them, but they have performed a notable effort, and I'd add that to anybody interested in Dave Collins's question as well. Okay, next we have James Patterson, who asks, do you at all discuss the work of Dr. Donald Lutz on how the founders used the Bible, especially Deuteronomy, over all other sources in their debates over revolution and ratification?
We do, but just briefly. But we do have a citation to Donald Lutz, and particularly he has that APSR article where he does a quantitative analysis of the citations in the political pamphlets of the founding era, and he excludes from his sample the political sermons. And so many of the arguments come forward in political sermons, but just for good measure, he excludes the political sermons and demonstrates, I forget what the exact numbers are, but that the book of Deuteronomy is cited, twice as much as all of John Locke's writings combined, something like that, more than Montesquieu and more than these other sources. And so there is a way of telling the story of the American founding, which is how it's been told for the last generation of scholarship, it seems, that you have John Locke, and John Locke articulates certain ideas, and those ideas are quietly really putting forward Thomas Hobbes's ideas, and the American founders just swallow that wholesale, and we have a Hobbesian republic. And I just don't think that's accurate in terms of what you find in the sources and what the arguments are that they're making. And Donald Lutz's work is really helpful in demonstrating that.
Yes, and for good measure, since he excluded those political sermons, we spent a little time on those, or at least some of them. For example, Jonathan Mayhew's A Discourse Concerning Unlimited Submission on Resistance to the Higher Powers, which Adams identified as as essential reading if you wanted to understand what influenced the feelings, what was baked in the bones of the revolutionary generation, and some others as well. But that was one of the important ones. We look at there's been scholarship debating about, is Mayhew actually a subversive thinker? Is he rejecting traditional Christianity? And the short answer is no, at least in our view.
All right, we have our next question from Herman Buma. George Washington stated that the freedom of religion involved the right to worship Almighty God according to one's own. So any responses to that?
I think it's certainly consistent with the way they thought about religious liberty, and Cody had already talked about that, but it does presuppose a particular conception of God. And I think one of the things that's helpful in how we're thinking about the classical Christian natural law tradition is that within that tradition, I think this is true of the medieval scholastics, as Cody points out. I think it's true of the Protestant scholastics. I think it's true of the Protestant tradition that informs the various denominations of the colonial colleges, that there was a widespread and widely accepted distinction between the knowledge that we have of God by nature, the natural knowledge of God, and the knowledge that we have of God by revelation. And the way that this is put often, this is how Calvin puts it, is that you have knowledge of God the Creator and knowledge of God the Redeemer. And knowledge of God the Redeemer, the plan for redemption and salvation, is something that's understood by revelation, but knowledge of God the Creator is actually understood by reason. And it's that knowledge of God the Creator that I think informs the political discourse that you find at the American founding. This is the reason why you have a lot of theological language. You have, for example, George Washington pointing to the Almighty, and you have language like the Almighty, you have language about God, about nature's God. You don't have very often explicit invocations of ideas that are held to be understood by revelation. And so when you find what we end up calling the civil religion sometimes in American politics, what you have is a particular conception of God the Creator. I think this is consistent with what you find in the Declaration of Independence. It's consistent with what you find in the invocations of providence and other things in the founding. And on their own terms, from within their own theological worldviews and frameworks, what they're arguing partly is that that is knowledge that we expect other people to have based on reason and not based on acceptance of a particular claim of revelation. And therefore it goes across multiple denominations, it goes across multiple religious groups. And so there's a kind of civic invocation of theology based on reason that helps structure and account for the arguments that you find with somebody like George Washington that you had just pointed to there. And I think that's a helpful way to understand what's going on with the theological language that you find in so many public documents in the founding era.
So I guess I have a little bit of a follow-up question there, or maybe it'll be redundant, but one of the things I appreciated about the book in the conclusion too is it made the connection between the view that Justin just articulated in many of the contemporary debates, some of which we've already mentioned, I think, during the opening comments, but maybe it was in our little bit of discussion before with respect to integralism, both Roman Catholic and renewed Protestant historiography, as well as it seems like some constructive claims about the way we ought to order our society and our polity that are at least interrogating disestablishment at the federal level, and seeming to equate that natural law, properly understood, consisting of duties to God as well as duties to neighbor, are the purview of the civil magistrate, and that natural law in the classical and Christian sense requires the government not just protection but the promotion of true religion. So I wonder if you guys could say a little bit more about that in terms of the that very clear, I think, relevance, providential relevance, perhaps, of the timing of your project.
Yeah, I'll say a bit of a word, and then Cody can jump in on this. But I think that our conclusion is that there's a broad range of prudential, institutional arrangements that we could make with respect to church and state. And so I don't think there's a one right answer for all historical contexts and all constitutions about how we relate these two things. There are principles that can guide us, but I think the American solution, as it develops first at the federal level and then disestablishment of state churches into the 19th century, is consistent with a natural right to religious liberty that's rooted in an obligation to worship God and to render to God worship according to conscience. That's the framework with which they're operating, and the institutional solution to that is not having religious tests for public office at the federal level. It's disestablishment of religion at the state level, and it's broad protections for religious liberty. Now, when you go beyond that, is that also consistent with the public promotion of religion? And I think, yes, you have days of Thanksgiving and fasting that are proclaimed. You have the government promoting a certain type of religious belief. And then you have a lot of nuance there. George Washington's farewell address, where he says that religion and morality are indispensable supports of political prosperity, also mentions the pious person along with the mere politician who equally should support these kinds of measures for public life. And I think he's gesturing toward the political utility of religion. And so that always puts you in a dangerous position from the perspective of the true religious believer, how much of this is being manipulated for political purposes and how much of this is based on a true respect for religion. I think we always have to keep that in mind as we're thinking through those things. But there is a broad role for prudence here in terms of how we make institutional arrangements with respect to church and state. And I think the American founding offers us at least one model for that that's consistent with these classical principles. I don't think there's anything about the classical view that necessitates or mandates a closer relationship than what we have in the American model. Cody.
Yeah, I think that was all well said. There's a lot of discussion, specifically in Catholic circles, about integralism. There's a lot more that I could say about that than in this webinar, but there's a recent lecture by my friend Russ Hittinger, who I think makes an excellent point that whenever one talks about church-state relationships as a matter of theology and law, one must attend to historical circumstances, and one will be prone to error when one does not. And, Washington's own approach to thinking about this in the farewell address, I think, is attending to the circumstance that he finds himself in, which is that there's a wide mix of different Protestant sects, and also a handful of Catholics and Jews around. And I think that he does acknowledge the duty of the civil magistrate to give thanks to God. And there is some duty with respect to religion, but it's underspecified. It's theistic and moralistic. But the details of the worship of God are left to these institutions in civil society. There's pragmatic and principled reasons for that, I think, that I kind of talked about already. But it seems to me, within the Christian natural law tradition, and specifically the Roman Catholic natural law tradition, at the very least, one possible legitimate juridical arrangement of church-state relations. That's all I've got with that.
So we have time just for one more question and then answer session. But we had two questions which are somewhat related, so I wanted to ask them kind of back to back and see what our panelists think. So the first one is a question that sort of gets to the heart of what were the founders doing, whether their project was actually sectarian or whether it presumed a Christian understanding. An anonymous attendee asks, am I wrong in thinking that the bottom line here is less a defense of specifically or consciously Christian ideas contributing to the American founding, and more a defense of the claim that the real object of natural theology is in fact the God of Christianity? It seems like the thing that the authors have refuted is the objection that nature's God is not the Christian God, but not the claim that the founders implemented their ideas in a non-sectarian way by avoiding creating an actually Christian state. And so that's one angle on it. James Patterson wanted to get back to the question of whether or not we were dealing with history or something based more on tradition or God-given natural rights. He asks, Jim Caesar notes that John Adams shifts from the rights of Englishmen to natural rights from the start of the revolution. Does this transition reflect an ideological revision, a renewed appreciation of the natural foundation for political rights? So kind of that question of origins, hoping we can take that up as we come to a close. Thanks.
Both good questions. Thinking of the first, and I did start off with the comment about the challenge, and the challenge is about the relationship of the God of nature and the God of Abraham, and whether those are mutually exclusive concepts. And our argument, obviously, by the end of this book is that they're not, that those are consistent. But it's also from the perspective of the religious believer, the believer in the God of Abraham. From their perspective, there's nothing contradictory about also affirming the laws of nature and of nature's God. But from another perspective, you could also only go that far, that there need not be a requirement that you go beyond what you understand by reason for the purposes of civic life. And so part of the claim is that you can have a political community, you can have civic life rooted in these principles among a plurality of views about what's been revealed and or whether there's any revelation at all. And so that takes us into each of the individual founders. And we are not claiming that Thomas Jefferson is a paragon of Christian virtue or he is a serious Christian believer, anything like that. We're not making claims about the actual beliefs of individual founders and claiming that they're Christians in that sense. What we are claiming, though, is that ideas that arise in the classical world and are modified and developed within Christianity and also then adopted by a distinctly American Enlightenment, as Jordan pointed to, has a particular American way in which those ideas are received, that tradition is the dominant influence of the American founding. But it's not the case, and I don't know if this is exactly what the questioner was suggesting, but it's not the case that it then therefore creates a Christian state. And in fact, far from it, if you look at the alternative model that the founders are, of course, working with, which is the relationship of church and state in England, they don't have a Christian state. And if we understand Christian state to be the offices of the church and the offices of the state being united, well, we don't have that. We have that juridical separation between church and state. We separate the offices of church and the office of state. Our senators, thank God, are not our bishops. And so we don't have those two things united. And so there is that kind of separation. But the key point, I think, is that in order to understand that separation and the reason for it, you have to go back to ideas that were developed within this classical Christian natural law tradition. And it's in fact the modern secular alternative that in the modern world, the arguments of Thomas Hobbes or Jean-Jacques Rousseau or some of these other thinkers that we associate with the Enlightenment who wanted to reunite church and state for their own distinct political purposes. And so I think it's important to understand the American project and the American alternative as stemming actually from a series of ideas that come out of this classical and Christian tradition that we're highlighting.
Yeah, that's a good point. So, another way of putting it is, how do you define an actually Christian state? I don't know that that's a necessary condition to define an actually Christian state, that you impose Christianity legally. In fact, that actually might not be a Christian state. But let me go to James's question about natural rights and Englishmen and the rights of Englishmen. It's a good question, and And the evidence that we found was that you actually have commingled appeals to both nature and the English Constitution from the very earliest pamphlets. Maybe Adams was less so, but for someone like Benjamin Franklin in his examination before Parliament, right after the Stamp Act, he says that it was neither agreeable to nature nor the English Constitution. So it was neither just nor agreeable to the English Constitution. So I think that you already have appeals to natural justice and to the English Constitution early on, but in the first stage of the pamphlet debates tries to duke it out. It is true, much more within the framework of the English Constitution, and to try to, and I think part of that was we're trying to redress grievances with Parliament. We're trying to show good faith to get Parliament to to change the law. We're not necessarily disputing its authority per se. And then you have a pivot in the second stage of the pamphlet debates, early 1770s, when the Americans, because the way the Parliament. So before I describe why they pivoted, or let me say why they pivoted, Parliament basically in the imperial pamphleteers basically said, oh well, Parliament is sovereign. You've admitted Parliament sovereignty, and the law is made by Parliament, ipso facto, it's just. So they made positivistic arguments rooted on the authority of Parliament, and so the American pamphleteers had to pivot, or they felt the need to pivot in their understanding of the English Constitution, and so they started affirming this so-called dominion theory that every legislature, the colonial legislatures, Parliament, were co-equal within this kind of constellation of the English or the British Empire, and the sort of uniting principle, or the sort of the sun in the solar system, was the king. That was the unitive principle was just our loyalty to the king. And there's much that could be said there, but this could be seen as part of that shift to the natural law rhetoric, is that they were trying to give first principle based justifications for that reading of the Constitution. But even then, they're still giving interpretation of the Constitution. So I think our position is that the constitutional and sort of first principles type claims were commingled throughout the pamphlet debates. So I don't know if Caesar would agree with that or not, but.
All right. Well, on that, I think we've come to an end. Please join me in thanking all of our panelists just for such a marvelous time on this webinar, but we'll also make available to everybody links to pre-order the book, The Classical and Christian Origins of American Politics. I don't believe it comes out until the end of the month. Is that correct, Justin?
Well, I apologize. It's an overpriced academic book, but we do have a paperback copy. And as of now, Amazon says it can be delivered by Christmas. So they keep pushing the publication date back, but we're hoping early December.
Listen, will you forgive one personal word? I realize I've known these two since they were graduate students in Texas. I just have to say, what an elegant thing you two have produced. Just can't say enough about it.
Well, thank you, Hadley. We appreciate those kind words.
Thank you so much.
Thank you all.